Coming up on this program, we show you how to get connected. Find out how to choose an internet service provider. Discover the newest form of communication, electronic mail.
Ways down and ready to ride. One by one, billion by billion, they're holding up half the sky. Raise your hand if you're ready and willing, if you know it's time. Time for a girl on time. Time for a girl on time. Time for Oh, I don't need these on right now. I hope everybody is well. Ahoy! I'm getting an internet signal saying, "What are you doing?" Okay. I hope everybody's well. I would like to thank the person who yesterday timed. I talked in the show where I am in and talking compared to the case. I mentioned like 16 times yesterday was a video that people could go watch if they didn't want to listen. Did I not say that? I'm fucking positive. I'm absolutely positive I said that about 17 times. And yet I actually, like, literally the person was like, "Yeah, you didn't actually post a video," without interrupting it. I was like, I'm sorry, what? I'm cutting out? Well, nothing to do about it. Put on some court, maybe? Anyways, let's see. Oh, so first case today, a little bit interesting and not child support. I downloaded it specifically because of the name. I think it's a civil case, and it is somebody versus Waffle House.
Procedural posture of this.
You're like diving right in, Mikey. Anyways, so like I said, this is a new court. I don't think I've covered this judge before. And Waffle House. I loved the Waffle House. I went there multiple in Florida. I really enjoyed it. Internet been fucked today? Something's been fucked up today, I'll tell you that much. I don't think it's the internet, but it says it's unstable. Anyways, Waffle House. I don't know what this case is about. Let's watch it. It's like 15 minutes.
All right. So I'd like to talk a little bit about the procedural posture of this motion to dismiss. I'm going to tell you what I'm inclined to do procedurally, not necessarily with regard to the merits of the motion. And then I'll be happy to hear from you all. And hold on.
Come on, Judge. Let this be about a waffle.
Yeah. All right. I am well aware that the Court of Appeals currently has in Simmons versus Solo Cup the issue of whether.
Did he just say Simmons versus Solo Cup? fucking totally did. Wow.
Workers' compensation exclusivity is a 12B1 jurisdictional matter for the trial court to decide, or a 12B6 matter that ultimately could result, frankly, in the issue going forward to the jury. The concern that, I mean, I understand that case to have been orally argued recently, so I mean, timing, I'm just guessing. I haven't actually looked at the effect of the two-term rule, but I'm guessing that there will be a decision in that one probably inside of 6 months. So there's that. You know, the problem that I have is that now, I'll say with regard to the facts.
Holy shit. Judge, are you even saying anything? Out with it. I was going to refrain. I was literally like, you know what, Paisley, you don't really need to roll and smoke a joint while you're live today. Like, why don't you just try and listen to the court, pay attention. And this judge has made me now roll a joint. Thanks, Judge. That one.
Of this issue. Now, both sides have presented evidence in the, you know, the defense and the motion, and plaintiff in response have presented evidence, though it's the evidence you have, not necessarily the evidence that was developed in discovery. 12B1 motion to dismiss would be a motion that where the court would sit as the finder of fact and make and decide the threshold jurisdictional issue. 12B6, if the court finds an issue of fact, you know, might then punt the issue to summary judgment. And frankly, if there is still an issue of fact, that would go forward to a jury. I will tell you as a threshold matter that I tend to agree with Judge Reed that it is a threshold jurisdictional matter. Though I don't have to, I have the luxury, I guess, at this point, since Judge Reed is the trailblazer, on this issue of waiting for a Court of Appeals decision, or I may have the luxury of waiting for a Court of Appeals decision on the issue and then proceed accordingly. In any event, I mean, it's.
Oh, now this is interesting. See, MB, I don't know what this case is fully about, but that would make sense if so basically, if there's a workers' comp case, then there's no ability to sue for negligence. And that would probably be because it's required in some jurisdictions for employers to be paying into workers' compensation insurance. So interestingly enough, when I worked at the bus company, it was a large company, and we dealt with a number of injuries and people going off of work, and workers' compensation insurance, which is run provincially here where I am, is quite expensive. And for a company of our size, what they actually did was create a in-house program for covering people that would be normally off on workers' comp. And allow them to have like reduced work duties, but pay them their salary. But basically it's all in a attempt to keep the numbers off the books, basically, of how many people they have being covered by this insurance plan. And I always thought that was really interesting. They called it a back to work plan, and they would allow people to sort of do reduced workloads, etc. But like they had to provide it, and it's a provincial company, so like a provincial agency. So I think that somehow they probably got away with that. Other companies, I don't think like a private company would be able to do that. This was a provincially regulated, what we call a crown corporation.
Seems to me, with regard to the facts of this particular case, the meal benefit and how it's used, and when it can be used, and what's supposed to happen when it's used, that there are significant issues of fact here. Potentially, anyways.
This is about a meal benefit? Like, do they get a free meal at work? Interesting.
And of course, if it's a threshold jurisdictional matter for the trial court to decide, and that's ultimately what the Court of Appeals decides, or if that's ultimately how the Court of Appeals, comes down in terms of how it's to be handled, that is a whole lot of litigation and potentially a jury trial that could result in a decision that ultimately says the trial court never had jurisdiction over this matter in the first place. I'm inclined to open up a limited discovery period, 2-3 months maybe, on the jurisdictional issue alone, meaning just because both sides have filed evidence without having actually had an opportunity to conduct discovery and engage in kind of the push and pull, give and take of the discovery process that ultimately, helps develop facts. So you presented kind of your respective sides without having really interacted in discovery in a meaningful way. So to me, I think it makes sense for me to open up a limited discovery period of 2 to 3 months on otherwise discovery will be stayed, but open up a limited discovery period on the jurisdictional issue, the use of the meal plan and how that interacts with workers' compensation exclusivity. Maybe a little bit of supplemental briefing, or in any event, y'all can feel free to file. Well, we'll have a supplemental briefing schedule. A shortened one though, a couple weeks on each side, couple weeks to file supplemental brief in support of the motion.
All right, this is just scheduling. I'm about done with it. I'll be honest with you. I will keep track of it because it sounds procedurally interesting, but I don't know that it's as interesting to everybody else for a Friday night. So let's continue with the child support or child custody cases. We started off the day, and here's the kicker. I can redirect you, but I'm not going to show this one tonight, but I did make a video today without me talking in it. So again, if you don't want to hear me talk, go watch the videos. I'm not there. Though I did make them. So, take that as you will. Yeah, so let's add
Kruger, 24-207-624 PP. This is the petitioner's motion to terminate a personal protection order.
Okay. First one actually is the motion to terminate a personal protection order. Look at that. Bam. Also, yeah, so this is in Michigan. And I figured it out, guys. We were talking about this. Some people were saying, oh, the judge has like there's a cameraman, but if you notice, he actually has a remote control, and he obviously has some presets to where he can set them around. So watch closely, and he's moving the camera himself. Judge cameraman, ladies and gentlemen.
Plaintiff is present in the courtroom. She is in pro se. The defendant is in the courtroom in pro se. Will both parties please raise your right hand?
Do you solemnly swear or affirm that the testimony you're about to give in this case is the truth, the whole truth, nothing but the truth, so help you God?
They put your hands down. The court, back on January 22nd, 2024, had issued a personal protection order. The petitioner in this case, Ms. Glinkerman, had filed a petition with this court. On that date, the court, based upon the information contained within the file, as stated, authorized the petition, and the very first alleged incident that the court relied upon in issuing the personal protection order is as follows. The latest incident started in early to mid-December 2023 with mental and emotional abuse. December 25th was the final incident. Kent Kruger and I started arguing earlier that morning, which resulted in him, Kent, cutting my arm with a knife, which I...
Whoa, on Christmas? Kent, what the hell? Why are you doing that on Christmas? That's terrible behavior. Oh my God, please tell me there aren't children. Can we just imagine the rest of their lives just going through, and then on Christmas morning, my mom was cut.
I received 5 stitches for later in the day. Later in the afternoon / evening of December 25th, while his children were at home, Kent accused me of stealing baseball cards, got angry, hit me in the head with a metal box. Kent's daughter called the police and I was taken to the emergency room where I had been examined and received my stitches. There are other alleged incidents in this matter as well. Since the granting of the personal protection order, the petitioner has filed a motion to terminate the personal protection order, where on March 15, 2024, according to the document filed with the clerk of the court, I, Leslie Glinkerman, have good cause to terminate the PPO against Kruger. I lied about the abuse and...
Oh my God. We got to watch that again. He's so dramatic.
Filed with the clerk of the court. I, Leslie Glinkerman, have good cause to terminate the PPO against Kruger. I lied about the abuse and made up the story of Kent cutting my arm. I did this so I would have a place to stay at the shelter. Ms. Glinkerman, do you have any comment regarding that?
Plead the fifth, ma'am. Plead the fifth.
I'm sorry that I lied and caused all this hassle of everything that's going on.
Shouldn't she plead the fifth? She should plead the fifth right now, right? Because he's asking her to incriminate herself about a crime, perjury. So I think she should be pleading the fifth. That's my theory on that. Now, hi, Grammy Rita. Welcome, welcome, welcome. Yeah, I don't think this is a good idea. I don't know that if he is, I don't know what the rules are for him asking, but she would be within her right to plead the fifth, I think. He's not super new. I posted a video of him today. I've watched him a little bit. I love the court. I think she is going to get in trouble because she did just self-incriminate herself. or drinking a fifth. I wouldn't, I would, you know, I'm going to recommend pleading the fifth.
It was a big mix up about Christmas. It was a big mix up about other stuff. I was mentally ill. He was also mentally ill, and I'm sorry.
Just a moment. Just wait a minute. You had stated, you just stated a moment ago, alleged mental health issues, but you filed this on, the document that you filed with the court was dated January 1, but you filed it on January 16. Correct? According to the file.
January, yes,
Okay.
because of where I was staying at.
So this is the problem with matters like this in general. Personal protection orders are extremely serious matters.
I feel understood.
And your admission that you lied to the court, first, I'm going to terminate the personal protection order. That's number one. Number two, I'm holding you in contempt.
Oh my God, the judge is so on it. He's gone to a shot of her face so that we can see her reaction. I'm shooketh. I am literally shooketh right now. If you couldn't tell, I didn't watch this ahead of time. If I did, I would have already made it into a video.
As a result of that, at this time, I'm not going to make a determination regarding disposition because at this point, I'm going to assign an attorney to represent you. This is frankly criminal contempt. My understanding is, well, as a result of this, right, just a moment, please.
Cut the tension with a knife.
You have an attorney representing you in another matter right now?
Yes,
What's that attorney's name?
Lockhart.
Mr. Lockhart? Okay. The court will appoint Andrew Lockhart to represent you. We will set this for a disposition hearing next Friday at 9 a.m.
Next Friday at 9.
Pardon me?
Next Friday at 9.
Next Friday.
Next Friday at 9 a.m., ladies and gents. That is going to be May the 3rd. Let's write that on the calendar together. 9 a.m. is, oh, fuck, that's 6 a.m. The things I do for you because I love you guys. Because I love you. May 3rd, 6 a.m. here on. Oh, if I will look at the calendar at 6 a.m. You're gonna have to remind me the night before. I should write it on the calendar the day before.
Don't ever do this again.
Will not happen again.
I'll see you next Friday at 9 a.m. Off the record.
That I just am like baffled. I didn't realize that was in there for 53. So I gotta make a note. Okay, what else did he have today this day?
Victoria Danielle Geyer versus Brian Chad Pickenu, 216994 DS. This is Ms. Geyer's motion regarding parenting time, custody, and other matters. She is present. Court calls Brian Chad Pickenu. No response. Matter is scheduled for 9 a.m. It is currently 10:05. The court did inquire of Ms. Geiger whether she believed Mr. Pickenu would be appearing. She advised probably not, I believe, for her words. She is in the courtroom, though. Would you please raise your right hand?
Do you solemnly swear or affirm that the testimony you're about to give in this case is the truth, the whole
This is cameraman Jack. That is his new name. I will not be told any different. Cameraman Jack, ladies and gentlemen, also known as the judge.
Truth, nothing but the truth, so help you God. I do.
Thank you. Ms. Schultz, what is the current order regarding the minor child and children?
Your Honor, on June 12th of 2023, a stipulated order was entered regarding custody and parenting time. That order granted the parties joint legal and joint physical custody of H with equal custodial time on a week-to-week basis, as well as alternate holidays pursuant to the 2016 parenting time guidelines. There was previously an order for Ms. Geyer to have sole legal custody, but the parties had worked on communication, has thus stipulated to the order in June. My understanding is that there's been a number of occurrences according to Ms. Geyer's motion that the court will need to consider. I just want to note that the friend of the court does still have a valid bench warrant for Mr. Pickens based on his failure to appear on a sanction.
Thank you. And the court took judicial notice of its own records as well. There may be a bench warrant out of the court as well. Oh, it's out of this court. I'm sorry. I was mistaken. Okay. Ms. Geiger, you are under oath. Why do you believe that we should be revisiting custody parenting times?
First off, he no longer resides in the county. As of far as I know, last I knew.
Okay, first off, I don't know that is what is going on in this county? How are these people filing all these motions without attorneys and getting in front of a judge? That's my question. Something's going on there. This is weird. They have joint custody with shared physical and joint custody. She wants a change in that to be getting primary physical custody. But I mean, you're going to have to show a huge change in circumstances to warrant a change in an order from just 2 months ago or 3 months ago. Wasn't that when they said that they settled on that order? Maybe we should just listen. Okay.
He was living in a garage in Bay City. I know he's been flip-flopping between Bay City and Midland. I don't know his current residence fully. I tried talking to his family even. It's just he doesn't reside in the county.
As long as he's 100 miles away from the domicile of a minor child, he can move. As long as he's within 100 miles as the crow flies. But okay, well, that's issue one. What are there any other issues regarding?
He was arrested about in March with having methamphetamines and an illegal unauthorized weapon.
Oh, what the fuck? Why didn't you lead with that? That seems really weird. Why wouldn't you lead with that? Now I'm confused.
The passenger seat. He has been aggressive again. And with the catching of the methamphetamines, I am under the impression that he's been using again. And I think that that's not safe around our daughter, H, at all.
Is he exercising his custodial time?
No.
When's the last time he did?
Easter. And that was because of his mother.
Easter was like a week and a half ago. Wasn't that like a week ago? Or maybe 2 weeks ago. And I think she is wearing a Carhartt jacket. But I mean, who's not these days living in Michigan?
Mother and I had communication so that she could spend time with them, and he was there, but not like present, according to the minor child.
All right.
Hearsay.
Mr. Pickett has failed to appear, obviously, and based upon the information provided, by Ms. Geyer. The court is going to order at this time.
Hold on, really? Was Easter really 4 weeks ago? I have to blame ADHD and my inability to keep track of time for that. Positive it was last week. Right? By the way, hi Kay. March 31st. Okay, so yeah, a while ago. All right. Okay.
On an interim basis, that Ms. Geiger have sole legal, sole physical custody of the minor child. Mr. Pickenu, if he wishes to address the matter, can file a motion to address that until such time as he files a notice of hearing, and we have a hearing relative to whether we continue this interim order or not. That remains up to him to decide. But I'm on an interim basis granting you sole legal, sole physical. Is there a support issue relative to this as well, Ms. Shore?
It's, while I'm looking at the file for support, Your Honor, are you also suspending custodial time?
Yes.
There is a support order in place. The parties had stipulated to $75 per month. It appears from the testimony that Mr. Pickenu is released from any incarceration. The court can verify that. Because
Do you know
he's
that?
still
Yes,
incarcerated.
he was issued rehab over the weekend, but he escorted himself out and has been MIA.
Which county?
He was in Boyne, he was charged in Bay County. He was rehabbed in Boyne, Michigan. And then as far as like I said, I'm not sure where he is at this point. Ever since he came out of rehab, I haven't received a call from him since then or any communication, but he does reach out after bedtime hours to the minor child.
Boing, boing. Yeah. Oh, 007. 007. Kay, if you just got here, by the way, you just missed the judge hold somebody in contempt of court for lying on a domestic violence case, which I thought it was pretty unique.
Shall we continue to support that?
Unless the friend of the court receives information that we need to review support based on investigation, we can either continue the order or we can look at support because there is a change in parenting time that we want to review as well.
You want us to look at the parent or the support issue as well?
No.
Just continue it as previously ordered? Okay. Support will continue as previously ordered. Interim sole legal, sole physical to mother. Any custodial time with father at this time is suspended. You can file a motion to address it down the road. Again, for the safety of the child. That's what the court's most interested in. You're free to go.
Thank you, Your Honor.
Anything else?
I'll just note that Ms. Geyer has filed communication complaints with the friend of the court office. We are reviewing those. But before we can take any action, we have to look at Mr. Pickenu.
With that app, actually, is there a way I can set a meeting with you on how to properly get that set up? Because I think there's actually an issue with the app itself because it kicked me out of the chat. And
Oh, so did you want to set up a meeting with the judge about that? Are you nuts? That's not what you do. Is that who she's asking? The judge? No.
I can't use it at
I'm
all.
gonna defer to Mr. Holdwick because he's our those expert. So we will call after we're done with hearing.
Thank you so much.
Thank you.
On to the next. What do you got now, Judge?
Anthony J. Davis. This is file number 16-201. 059318P. This is time and date set for show cause hearing.
Yeah, I think she did want a meeting with the clerk, but the clerk can't fix the app. But we all know what the real issue is when there is a, it's user error for the most part, right? Like we know that. We know that. The judge sounded like a robot there. It scared me a little bit, not gonna lie. He had a busy day today. He had a busy day. I don't think I got everything, but I got quite a bit of what his day was. His busy day equaled my busy day. Thanks, Judge.
Mr. D'Anthony J. Davis appears via the Zoom application. As I understand it, he's currently lodged at the Huron County Jail. Back on March 21 of 2018, this court issued a bench warrant for the defendant, alleging failed to appear as ordered on March 14, 2028, or at least contact in front of the court office.
Hold on, did he just say 2028? I'm actually positive he did just say 2028. But he means 2018. But let's listen carefully.
Alleging failed to appear as ordered on March 14, 2028, or at least contact in front of the court office. That was authorized on March 21, and on March 26, certificate of mailing was also filed in this matter. Bench warrant was signed March 23rd. Also appearing in the courtroom in this case is Mr. Mitchell Holwick. And Mr. Holwick, what would you like to tell the court, please, regarding this matter?
Your Honor, I just kind of, I guess, back up on everything. Mr. Davis had originally had a show cause for non-payment of child support back in 2017 that he failed to appear for. He was arrested on that in September of 2017. At that hearing, the court had.
We call him Cameraman Jack, but he's also a judge. I'm gonna write a story about him later.
Discharged the warrant, sentenced Mr. Davis to 30 days in the county jail. That upon his release, he was to meet with me in person to establish a payment plan. He did not do that, but he also had employment and payments were coming through. But that was the last time I talked to Mr. Davis, with the exception of yesterday. The court had actually scheduled a show cause for March 14th, 2018 at 9 a.m. For Mr. Davis failing to participate in the attendance of the SMILE program that was ordered previously. And I guess for the record, when this was ordered for SMILE, it was when SMILE was conducted in person. So
We ordered him to smile in person, and he refused. He steadfastly refused. In fact, he was giving us frowns, only frowns. I know it's a program, I'm sure it is, but we have to laugh about something.
there were specific dates that he had to take them by. The information, the notices, they were all sent to 7521 North Beacon Court in Canton, Michigan. Speaking with Mr. Davis, that is still a good address. That's where all of his mail's been going. Unfortunately, he did not appear for that show cause on March 14th, 2018, and the court issued a warrant for his arrest for failing to appear with a body bond only. So he is here before the court on a body bond for not taking the SMILE program that's been ordered since 2016.
Do you guys have Body Break in America? Did you have that little I bet you didn't. Body Break in like the 90s? Oh, I think that was Canadian. Oh dear. We're gonna have to talk about that in members only this week. Body Break.
2017, I believe. Speaking with him currently, his support's about $587.50 per month. He is just over $31,000 in arrears. Last payment was being in October of 2022. Mr. Davis did state in my notes previously from 2017 when I spoke with him, he had some shoulder surgery in February of 22, and then he had multiple hip surgeries in the beginning and mid-year of 2023, most recently being in August this past year. So he has been off of work since the end of 22, and then was dealing with procedures the majority of the year for 2023. He was actually set to start.
Probably not, Vicky. I'll probably be on tomorrow, actually. I will be on tomorrow because it's the end of the month. Hi, Bad Scooter. How are you?
Started a job before he got arrested. He just was in the car with, I believe he said his girlfriend. There was a blinker or something not working that caught the attention of law enforcement. He had a warrant. Also, though, regarding this report, Mr. Davis has had a warrant from the Attorney General's office for felony non-support. So I believe he also has that other issue going on, set for arraignment this afternoon down in district court. But regarding the front of the court warning, it's just a body bond, not taking file program and appearing on March of 2018.
Okay, but also, is it fair to say he's alleged to violate the court order that he's supposed to meet with you after his release from county jail to set up a payment?
Yes, we did discuss that too. He does not recall getting a copy of that. Typically, when the individual is sentenced on one of our warrants and does receive jail time, when that order is signed, a copy is one, placed in the mail, and two, walked over to the jail for the inmate so they have it when they are released so they know what's going on. He does not recall that. He said if he remembered it, he would have came and talked to us. But nonetheless, he didn't show up for the.
Yeah, that's the one. And if you watch it and I hit body break perfectly. Body break. Yeah, I'm hitting that note A fucking plus. Basically, it was like a little, I don't know what you would call it, like public service announcement type show. Like obviously somebody paid for the show, but it aired during television shows and it was trying to get you to like move your body and have a body break. And but they wore like really funny aerobics outfits and the song was quite catchy. Christy, are you really talking about boars? I would try predator urine. I think you can get that on Amazon.
Payment plans, but like I stated, he did gain employment and we were getting consistent payments from an employer for quite some time up until October of 2022 when they stopped. And that's around the time he was having issues, and shortly after that was having the procedures.
Mr. Davis, would you please raise your right hand?
Do you solemnly swear or affirm that the testimony you're about to give in this case is the truth, the whole truth, nothing but the truth, so help you God?
Yes.
Thank you, Mr. Davis. You may put your hand down. Mr. Davis, did you have the opportunity to hear everything that was stated by Mr. Oldwick a moment ago?
Yes.
Okay, and how do you respond to all this?
It's truthful.
So in case we missed it because we were too busy talking, this dude's behind in his child support $31,000 and he's been on the run since 2018. Am I getting that right? I think I'm getting that right. 2018, 19, 20, 21, 22, 23, 24. That's 7 years. He must have just broke a mirror.
The SMILE program now is offered online. Correct, Mr. Oldwood?
Correct, Your Honor. And might I add too, with this case, speaking of Davis, the other party is not in the county. They're actually down in the city and constant contact. So
Constant contact leaving.
between the parties.
Okay.
So they do have communication regarding the support issue. He did mention that he has paid her when she's needed things, but they just haven't come through the proper channels on the issue. But I just wanted the court to be aware on that as well, because, you know, SMILE was ordered. But the parties have demonstrated that they do have effective communication, and
That's at least good.
so I just want to put that on the record for that.
But he didn't show on March 14 of 18.
He did not.
And Mr. Davis, can you explain to the court why you didn't appear at that court date?
Cause when I got transferred up here, I had a previous case I had went to court for before I had got brung up here, and I had probation, but since I was locked up here, I had missed probation, so I had to go back down there to court to serve my jail time there. So I didn't get to it right away.
But you did receive notice of it, obviously, because according to Mr. Holwick, that address that you listed is still a good address, correct?
Yes, this is a good address.
Okay, so after all that was said and done with the jail and stuff in the other county, why didn't you just call Mr. Holwick to set something up? Or at least explain why you weren't there?
I have no answer, sir.
I respect your honesty, though. I find Mr. Davis in contempt for failing to appear. It's refreshing to hear no excuse or anything like that. Mr. Holwood, do you have a recommendation?
I do not, Your Honor. I'm going to leave this up to the discretion of the court, given that SMILE is online. This is kind of a different warrant that we've had to issue, being that it's not for child support.
Are there any pickup fees, or there's clearly booking fees?
Yeah, I believe a $12 booking fee, and typically I ask for $75 transfer fee to the sheriff's office for transporting to the county.
Mr. Davis, is there anything you'd like to say to the court before the court imposes disposition for the contempt?
No, sir.
Thank you. All right, court will order. And sir, do you have any money available to you right now?
No, sir.
Okay, do you have any available to you at home if you were released?
Yes, sir.
Court will order that Mr. Davis pay to the Huron County Sheriff's Office $75 for the transport fee, $12 for the booking fee, total of $87. If you were released today, Mr. Davis, how long would it take you to pay the $87?
I would hope by like this afternoon, because my ride has to drive up here to come get me if I was released to bring the money. So.
All right.
Can I add something to that, Your Honor?
Sure.
Mr. Davis, with the AG warrant that's going on downstairs, I don't know what's going to happen with that arraignment. I do know typically that's 25% of his arrears, and at the time it was just under 20,000. So I believe his bond on that is almost $3,000. I did reach out to Mr. Davis's mother upon his request after I spoke with him, provided her with that update. It didn't sound like there could be payments coming, but again, that was yesterday. I'm not sure if something would change. My recommendation, Your Honor, would just be that within 30 days of his release from incarceration, because again, I don't know what's going to happen with that Attorney General case.
Sure. Court will order Mr. Davis that you pay $87, and it must be paid within 30 days of your release from the county jail. Court is going to recall the bench warrant that brought you here. At least the court's bench warrant.
Okay.
Court will also require that within the next 30 days following your release from the county jail, that you attend, and I'm assuming, do you have a computer or cell phone available to you upon release?
Yes.
Okay. I don't presume anything. And the reason I ask that is because now the SMILE program is exclusively online. So you don't have to go anywhere. You don't have to do anything other than dial it up, and you have to watch the entire thing. It knows if you've not been watching, and then at the very end, there may be some things you may have to do, but then we'll receive verification that it was done. If you do not complete the SMILE program within 30 days of your release from the county jail, you shall serve an additional 30 days on top of that. Do you understand?
Yes, sir.
You were picked up yesterday?
He was arrested on the 24th.
Thursday?
He came,
Wednesday?
he arrived at our jail yesterday, the 25th, but I had received a call from Central Dispatch that he was arrested and being transported late in the afternoon on Thursday, the 24th.
So I'll give him 2 days credit.
Yes, sir.
I'll give you 2 days credit on that 30-day sentence. So if you complete the SMILE program after the 30 days release and pay the $87, 30 days after your release, no jail time, no nothing. Is that fair?
It's fair, Honor.
I'm trying to be fair to the circumstances, but down the
I think that's more than fair. Doesn't that feel more than fair to anybody else? Also, I want to have a bath tonight. I think I want to have a bath. And Christy, it's probably less sophisticated and more something like tracking to make sure that you're not out of the app. But it's possible. I mean, most workplaces that have people working from home now have access to see their cameras on their computers, but piece of tape works great for that. I read this thing where I can't remember who it was it, I can't remember where I read it, but the lady was like, I put a Band-Aid over top of my laptop camera, and every time that they would ask me to turn on my camera, I would try, but it would be covered, obviously. And then finally they said, you have to bring your laptop into the office for us to troubleshoot it. So of course I take off the fucking Band-Aid, bring it in, it works. And then when I got it home, it didn't work again. And they just called it an issue they couldn't fix. And I didn't have to do, the meetings on camera anymore. Yeah, there's lots of tracking apps, lots of things like that. Lots of that kind of stuff.
The road, keep watching your mail. You see something, don't ignore it. And if you miss it, it's a lot easier simply to call Mr. Holwick's office, let him know what happened. Chances are we can avoid matters like this in the future if you do so. I'm just trying to give you some advice. I don't think you want to hear either, do you? No, I don't think so. So that's what we'll do.
Hold on, I'm not scamming any system. I don't have a boss other than YouTube Daddy. And here's one trick. I've told this story so many times, but I'll tell it again. I shorten it now. I used to work for AT&T. People would call in with tech problems. People were annoying. When they would call in and I could tell that they were stupid, I would say, okay, thanks so much for calling. Are you calling about the phone that you're currently on right now? And they would say, yes, I am. And I'd say, okay, no problem. Go ahead and remove the battery. And then their phone would disconnect from me and I wouldn't have to deal with them anymore. Now, I'll give it to them. There was a few people who were like, is that not going to disconnect us? And I was like, oh, yeah, you're right. You've passed the test. I will help you. But yeah, most people just got hung up on. And then you would call back their voicemail number and leave a voicemail. And just say, thanks so much. Try again. Bye.
Anything else I missed, Mr. Holwick?
So regarding our warrant here, Your Honor, it's been recalled. The 30 days is held in abeyance, but he has to
Yes.
go up. So I'm just thinking for purposes of the jail, I know he's got his other issues here. So is he ordered release on this warrant
Yes,
today?
I'm ordering his release today on this warrant only.
Okay, thank you, Your Honor.
Mr. Davis, do you have any questions, sir?
No, sir.
Okay. That'll be all. Thank you.
Thank you, sir.
You're welcome.
Okay. Last case. You hate AT&T? Man, listen, James, people did not like it. This was, when was this? 2000s? Pre-recession, early 2000s. And but obviously, yeah, when you could take the phone out of your, or the battery out of your phone. Okay, last case for tonight.
Regarding parenting time, she is present. Mr. Richardson is present as well. Please raise your right hand.
Do you solemnly swear or affirm that the testimony you're about to give in this case is the truth, the whole truth, nothing but the truth, so help you God?
Again, please don't refer to the child's first name, initials, appropriate. Anything in front of the book.
Your Honor, the stipulated order of support that entered on November 15th of 2010 granted Ms. Blunt physical custody of the minor child. The parties have joint legal custody. And there is a parenting time order that is subject to the 97 guidelines. I just want to verify that that wasn't subsequent.
That must have been weird for you,
The
James.
schedule has continued through.
Very weird.
Wow. Okay, thank you. I read the motion and it appears that mother's issues deal with the Wednesday visit as well as extracurriculars. Is that correct, Ms.?
Yes.
You want to explain that to me, please?
So the reason why we haven't been in here in many years, normally we're pretty mutual on agreements. But as our child gets older, he is,
How old is he?
he is 14.
Wow.
Yes.
They grow fast.
They do. Michael has not utilized the Wednesdays. I have reminded him multiple times. He will for a while, and then they just go away. And Dee has stated to me that.
We can't go to what Dee may have said.
Okay.
What about the extracurricular?
Isn't he a party to the case? Oh, wait. Well, this is a bit of a legal nuance. I thought that Ariana and Olivia, did I get the pronunciation of that right, Christy? Hi, Ariana and Olivia. You guys are so cool. And your grandma's cool too. And if that's not how you say your name, I'm sorry. But you can talk to your parents about that. That's a spelling issue. What was I saying? Oh, so he is, so hearsay is an out-of-court statement offered for the truth of the matter asserted. So if that, but an out-of-court statement, but not made by a party. So the exceptions to hearsay would be one, it's a statement made by the parties. So her statements would be exempt from hearsay and his statements would be exempt from hearsay, right? But does that only count if he's there to answer to those statements? That's the question. Now, if it's a child statement, that's not good. But I thought she was saying it was his statement and he didn't show up. But now my question is just about that. Oh, I'm so glad. Yay. Love it. Love it. Big words, right? I'm thinking about it.
So sometimes they fall on Michael's weekend and then he misses out on those.
What type of extracurriculars is Dee in?
He is in archery and baseball.
Archery and baseball. Mayor, thank you so much. Also, guys, remember, Mayor has posted on the Discord his Corvette project he's been working on. Go and check that out. Yeah, I think that is the case, Kate, which is interesting. Very interesting. Very interesting. Because it sort of like exempts conversations that you might have had. Thank you again, Mayor. Appreciate you. Get some sleep though. Yeah, judge's discretion. And she's not represented. So again, there's a lot of pro se people in this court. I find it a little weird.
And I'm assuming there are activities that occur during father's time as
Yes.
well. And what's going on with those activities?
Normally they are a few hours away or something. So like, especially with archery, those are on Saturdays or Sundays. And I provide transportation.
Actually, that was excellent form. I'd like everybody to just please watch again. As I pull it back, you see how straight my elbow is, and I bring it here. And then in archery, really, it's just a letting go. Because I did archery classes too, guys. Yeah, I did. Oh, sort of want to do that again. Feels good. Weird.
There, when it's his weekend, he just doesn't go.
Okay. Ms. Schultz, can you give some information to the parties relative to that issue of extracurricular?
I can, but can I ask for the court to first verify what schedule they're following, because our order doesn't have any Wednesday visitation.
Okay.
So if they've been doing a prior agreement, that's totally fine. I just want to have an order that reflects what the schedule actually is.
Like I said, we've been pretty mutual throughout these years and stuff. I'd like to take back a little bit what I stated. This year, he has now taken him to some archery tournaments.
And as it relates to extracurriculars, the friend of the court's position is that we fully support any activities that a child is engaged in. However, it is
Any activities? I don't think that any activities mean that. But I know what she means. This court is kind of in the sticks, I guess, eh? You taught archery for many years. Good form, right? It was there. Yeah, I actually enjoyed archery, but it's the type of sport you can't really practice by yourself. Like, there's no like, oh, I'm just about to, well, at least not where I live anyways. Like, you can't just, hey, mom, I'm taking my bow and arrow out to the, I mean, where I grew up, there was a parking lot behind our building, like our townhouse unit. You would not get along with that very quickly. It would be shut down. But there are so many freaking Karens in my neighborhood. They actually shut down kids' lemonade stands and all that kind of stuff. It's just terrible. Absolutely terrible. Yes, my piano is great. I love banging on that thing. Bang on it all the time. Even play it once in a while too.
the other parent, whichever parent has that custodial time, is their right to make those decisions on what activities they participate in. I would encourage that if, especially with archery, which I think is a relatively short season, 2 months approximately.
No, it goes from March until May, I believe.
So a little bit longer. Before doing enrollment, there really should be a discussion about how that impacts the schedule, and how you can adjust the schedule to make up for that. So as an example, if you can't go to visits because of a tournament, then maybe we need to add some additional time to summer break or spring break or winter break to offset.
Try to make it flexible. It sounds like you've been both flexible relative to the time otherwise. And by the way, the court adopts that same policy relative to extracurricular activities. However, when the court says that, it looks to the other parent who may not be taking the child
I've been saying that forever, cellulite yoga pants. They need to be selling like the gummies, but you get a full pack of regular gummies and then like one gummy that's medicated, and then you can eat both. I also remember a time when I worked at the dispensary, we sold baked goods. It was way less regulated back then, and baked goods. And somebody came in, and I don't know what quite happened, but they purchased something, and you weren't really supposed to consume in the dispensary, but again, it's a muffin, right? And so Buddy, like, I'm talking to somebody else, and then Buddy's his friend finishes up and then turns around and he's like, so how long is this gonna last? And I was like, oh, well, you're gonna cut that up. Like, that muffin's like, probably 5 doses at least. And if you're a beginner, even many more doses. And he's like, what? And I was like, yeah. And he's like, I just ate it. I was like, you just ate the whole thing? He was like, yeah, I was really hungry. And I was like, oh my God. You're going to need to make a very quick decision about either hanging out here for like 8 hours or getting your ass home. Like, now.
Certain events and say, for instance, why would you deny your child an opportunity and be in an activity that your child definitely enjoys? And if a parent is there, and maybe the non-custodial parent in this situation, like dad, I mean, that's great bonding time. And it's a shame if a parent doesn't want to follow that. Now, there may be reasons why the parent can't follow it. They work or they have some other things going on, but the court follows the front of the court policy, but strongly encourages the other parent, dad, for instance, in this situation, if it's true, that even though you're not mandatorily required to take the child, you're really foolish in not doing it. Because again, if that child loves that activity and the non-custodial parent has time to share that with that child, that creates a better bond with the other parent as well. So, Mr. Richardson, what is your response to all this, sir?
Well, sometimes I do say I don't think he should go to these activities because he has F's on his grades.
Wait, is this a new case? He's here. So that must have been child hearsay then. Also, we'll talk a little bit about weed after the end of this case. There's some good starting points for people, obviously. Keeping notes is very helpful. We can definitely help you, Mayor. I would absolutely prefer you to work on finding weed that will help rather than opiates. And I guarantee that. I guarantee that will be better. And you can always fall back on the opiates if you need to, but I promise you, I've gotten people off heavy duty narcotics using marijuana, the right type. And it is that entourage effect and what Lisa was talking about, but we can simplify it. We can simplify it way down. So it is all trial and error though, because of it's natural, But I would avoid opiates as much as possible, especially if you have an addictive personality. And I know, Mayor, you've shared with us before how many years you have sober, which is amazing. And we're so proud of you on that. And I know it's different substances, but still, And so, Kay, if you want something for your anxiety, you would want to stay, well, it depends what your anxiety is like. Is your anxiety the type of anxiety where you don't want to be stuck in your own thoughts? Or are you anxious and like nervous talking to people maybe? Because basically, if you don't have, if you get anxious from being within your own thoughts, indicas are going to be worse for you. If you, and so you'd want to go with something hybrid sativa leaning. If you are like But if you don't want to get all hyped up, then you would want to go more onto the indica side. Again, in reality, what you're looking for are the terpenes within the marijuana, because those are what give you the strain effects. So strain effects are the things like giggles, hunger, tiredness, laughter, having a good time. Those are the effects of the strains, and they're caused by the different terpenes. Everything that we eat has terpenes. That's what makes things smell like things and taste like things. So for example, you can have the same kind of terpenes in a mango that you can get in certain strains of weed. Now, the reason that I mention terps and terpenes is because in reality, you need very little activated THC in order, which is the psychoactive part of marijuana and the part that most people are most worried about, because it is what changes sort of your perception. And so if you are able to really tailor and zone in on what terps or terpenes affect you positively. So for example, limonene, LIMONE, gives a lot of people happiness. Myrcene is the one that goes into the couch. And so if you start to recognize that, my view of where marijuana industry will go is that eventually people will say they want to be happy. They will find the terpene that makes them happy. And then you add just a tiny little bit of activated THC in order to get it going. But you really don't need to be smoking or using a lot of them. That's the ideal situation, when you can hone in on different strains and find out what the terpenes are in them. When I was managing the dispensary, I bought terpenes once I bought 0.25 of a milliliter. Think of that, 0.25 of a milliliter. And they were $50 for 0.25 of a milliliter. But the reality is that they're very, very hard to come by properly. And please, this is the last thing I'll say before I let the court play, because I realized I just talked about the weed anyways, is food grade terpenes are different than marijuana terpenes. So what that means is if you're looking at a marijuana product and it goes ultra blueberry or mango mania, and the taste is like overwhelming and it's made with a distillate and terpenes, ask them, hey, are these food grade terpenes or are they marijuana terpenes? First of all, if they don't know the answer to that, that's a big red flag. But most likely it'll be a food grade terpene if it's cheap. If it's expensive, it'll be a marijuana terpene. And the food grade terpenes are allowed for ingestion, but they haven't been tested for smoking. And so I really would stay away from those if you can. Just stick with pure marijuana terpenes if you're going to look at that. And yeah, if you go to Leafly or many of the different websites, you can see the breakdown of the terpenes. But it is very difficult and sometimes hard to know because everybody's is different. So what might help one person with depression, like might be a sativa that in the morning gives them the energy to get moving and clean their house and get stuff done. But that same sativa for somebody that experiences depression might also make their anxiety go high. And so the other person might need a totally different approach to their depression. And that's because everybody's depression is unique and everybody's mental sort of well-being is unique. And so that's why, unfortunately, it isn't as simple as like take a Tylenol and it will do this. It is very much trial and error. But what I will finally say is that if you are doing trial and error and you do have a leaning towards anxiety, CBD, just pure CBD, is basically an antidote to THC. They negate each other at the same levels. And so what that means is if you have THC, which is the one that makes you high psychoactively, and you don't want to be high anymore, you add CBD and you aren't high anymore. So they sell sublingual CBD sprays. They sell CBD tinctures that you can take. But especially when I was helping people in person learn these things, that's a tool that I kept with me all the time, like a magic spray, literally. Like, oh, you don't want to be high anymore, babe? I got you. No worries. Like, we're good. And that's, you know, that's just comes with experience, right? Okay, let's finish this court case and smoke some weed.
Back in our day, we used to have seats, to play school sports.
I
Now
couldn't
they-
imagine though, I couldn't imagine though, this is a public school that the child attends? We don't even know which school, it's a public school?
Yes,
Okay. My understanding, and both parties can tell me if I'm wrong, but if the academics are not there, the child would be precluded from playing until the grades are picked up. Is that your understanding, Miss?
There's something I'd like to state.
Well, no, I'm asking you a question.
Yes.
Okay, and sir, is that your understanding as well?
yeah,
Okay. Mom, is he getting these very low grades as alleged by dad?
He does at times. He gets extra help during school. He does have dyslexia. And he gets help, like he has special
And so this is unfortunately a case here where this mom needs somebody to advocate here. So unfortunately, Your Honor, he's actually diagnosed already with a learning disorder. And so he's assisted at a school level for those things. And in fact, is on a bit of a different grading structure. So while it may be true that the average student doesn't get to play if they don't pass a sport because of his unique needs, that's not exactly something that we would be following here. Now, that's what she should say if she's the mom at the school. In the court, I guess the judge wants to hear that they're going to make them not play if he doesn't fucking get grades, which I hate. My daughter's school does something like this. I call it shame day. That's literally what I emailed the school about. I'm like, in regards to your shame day, where you want to hold the students in that are behind. And they're like, we call it CC day, complete your work day. I'm like, oh no, I recognize what you call it. I will call it shame day, and my daughter will not be participating in it. And after that, they needed a permission slip. Because I made them do it. I was like, I don't actually think that that's appropriate, especially since you're overrepresenting the kids that already have trouble with school and then ostracizing them away from the other students. No, we're not doing that. No.
in classes and stuff that
Okay.
teachers help him throughout the school.
Okay.
And I've never been notified that he can't participate in a sport because of the grades.
All right. It doesn't sound like father has the Wednesday midweek visit, so that point, court finds move. But relative to the
I'll walk away for 1 second and Miss Donna. Thank you so much. Oh my God, you're amazing. Make sure you guys have got gifting turned on. Members only this week. Guess what's happening? Oh, 5 friends got them. Yes. 5 friends are coming to the party on Sunday, and we're going to talk about Body Break. Ooh. A very fun Canadian classic. Thank you so much, Donna. Appreciate that. Hope you're doing well. Hope everybody's doing well tonight. Obviously, my most recent dose of caffeine has kicked in. Also, talking about stuff like that gets me riled up. Gets me all riled up. Thank you again, Miss Donna. But yeah, basically the school, it's just so short-sighted. It's like, oh, these kids that are already behind, let's keep them in on one day so that they can make a minute amount of progress towards them being better, but will make them feel ostracized, will make them feel different. It's just fucking stupid. Just stupid. Anyway, I love ya. Love ya. Mayor's going, ain't no rest for the wicked. Please be careful, Mayor. Drive safely. If you're driving, go to sleep. Go to sleep. It's true. It's true. And it's unfortunate because sometimes teachers take it as like a personal insult to them when a child is neurodivergent or doesn't follow the same path. And again, what I learned going through school as a kid with an undiagnosed neurodivergence was I wasn't really bothered by not knowing what other people knew in the same way. That never bothered me. What bothered me was people telling me that I didn't try, or people convincing me that I wasn't giving it my all. And I began to believe that. And so my goal entirely with my daughter was always to make sure that she was happy and that she did her best at school. But I give literal no fucks about certain curriculum standards, etc. And luckily I have her IEP to go behind that and be able to do that. But it is indeed one of those things where I find it sad when you realize like she's told me before, she's like, Mom, there's another kid in my class that the things that you get for me would really help them. And I like their mom doesn't do it. And it's like hard to explain that. It's like, I don't know, you can't be for everybody, but it is difficult because children that have that have a higher likelihood of having somebody who can't advocate for them. It's just the way it is. It's a cycle.
Relative to this extracurricular, I guess I'm kind of curious, do they make special accommodations based upon the child to allow the child to be in an activity?
They may, yes.
I'd like to know that if that's the case, though. That would be important. Because I understand Dad's position as well, but
Could I add also?
go ahead.
I have not denied taking. I said I don't think he should go, but I do take him. I'm trying to help him learn stuff at my house. That's cooking, mechanic work, building. He's real good, smart at that stuff. He does tell me he don't want to do archery.
Okay, I can't go to what the child may have said.
Yep.
I can't go to what the child may have said, but he's in archery right now, though, correct?
Not currently, no, because he's done with it because of him going on a school trip. So there won't be him going to nationals.
What grade is he in?
Eighth.
Eighth grade. What about baseball? Team baseball at all?
Not currently. I don't have a schedule yet. He is signed up.
All right, here's the ruling. First, again, as I stated, regarding the motion relative to removing the Wednesday midweek visit, it's not in the order. So as I stated, that's a moot point. Regarding the extracurricular activity, again, the court's policy and procedure is simply this: strongly encourage it, but if it's on the other parent's time, that other parent has the final say. However, again, Mr. Richardson, I strongly encourage you to think about that, because if the child is interested in the particular activity, whether it's baseball, archery, or building, it doesn't matter what it is. I mean, I guess you could put the shoe on the other foot here. If he's interested in building trades and on mom's time, who has primary custody, says, oh no, we're not going to be doing that. I mean, you understand how that could be affects the child. It goes both ways. I strongly encourage you to be involved in the child's extracurricular activities, but I'm not ordering it. I can't order it under my policy and in front of the court policy. But I strongly encourage you both to sit down about this. And if indeed, because you're able to communicate, if your son doesn't want to do archery, that's a family discussion. If it's baseball, that's a family discussion. But I have to deny the motion relative to the extracurriculars based upon the court's policy. But I think I'm speaking to two reasonable people here that can talk with their son and come up with something that's going to work for everyone. Because I'm, again, no disrespect to either of you, I care about your child. You're both free to go.
You're free to go, says the judge. My roommate might be coming in. Hold on. Just hold the phone for a second, guys. Let's just see. Earlier, I heard a knock on the door. I was like, what the fuck is that? And he's standing there. He's like, can you shave my head? I was like, what? I'm live. He's like, just the back. I was like, okay, I guess. Jesus. So now I'm realizing there's hair on the floor right there. I'm gonna have to go clean up. That was lame. Why did I do that? I should have said no. No, I'm not putting it on. No, it's already mostly, he did most of it himself. I should have left it. Sometimes he's still out there. He's still out there. I don't want to say it, but sometimes I do a bad job on purpose of shaving him. Well, probably should have hired somebody other than just relying upon me to do it. I mean, to me, it looks good, so I'm not lying. It looks good, but it looks good to me because I'm laughing about it. Again, the things we tell ourselves to make them true. Anyways, that's actually good news, though, if he's going out. Oh, I heard the bike. He's out. Okay, he's out of the house. That means I get to have a bath. Undisturbed. An undisturbed bath. I'm assuming that Kay got an alert on her channel, a copyright alert. Your husband does the dishes poorly on purpose. Uh-oh. The bike's off. He's coming back. Hold on. Now something's going on. What the hell is that? I may have to sign on. Huh. Can you guys hear all the birds outside now? I actually have, see, now I'm going to, hold on. Hey, what's that? I gotta go. We gotta play the outro. I love you guys. I'll talk to you later. Something's going on.